Thank you for providing us with a transcript of yesterday's proceedings. It will be very useful.
I'm grateful, my lord. Before I dive back into ground 3 of the cross appeal, yesterday my Lord Justice Holgate asked about the definition of rules within FISMA, and I've handed up with my learned friends' kind permission a one-page summary on that, setting out the rule-making power in FISMA and then the definitions in FISMA, and then picking up my lady's point yesterday about the use beside the tram lines of a numerical, or rather alphanumerical code, the Reader's Guide, which is published by the FCA to accompany the handbook. I hope that joins the docs.
Yeah, and that's the agreed position.
Well, I'm afraid I didn't give my learned friends enough notice to solicit their full agreement, but I don't anticipate it being controversial.
They can make them.
Indeed. Turning then back, if I may, to ground 3. Yesterday I reminded the court of the various contracts and parties involved in the relationship, and we looked at some case law to the effect in my submission that it's perfectly possible for various entities within a tripartite relationship to owe duties even if not contractual. Can I then turn to what I say the content of the duty of care is in this case? Can we turn please to the judgment as to what the judge found the relevant standards were for selling PPI. It's in the core bundle, tab 9, page 132. And on page 132, you will see paragraph 132 at the bottom. And I wonder whether the court would please read just paragraphs 132. I'm sorry, 130 to 132. So bottom of page 132, going over to 133.
Yes.
I'm grateful. And so you see there, the judge found the relevant standards were not those of being required to provide advice as to the merits of a product, but they were to provide fairly basic information as to the nature of the product, the eligibility requirements in particular, the key benefits and the key exclusions. And so that would allow the consumer, at least in theory, albeit in the context of a fairly rushed transaction, to make some sort of informed choice as to whether they wish to buy the PPI policy.
And so how does that read across into a duty of care?
Well, what I say is that the duty of care is a duty to take reasonable care in providing that information and not misstating information, but also providing those pieces of information in whatever form may be most convenient, but so consistent with.
The duty is what? To provide the information, or to take reasonable care to provide it?
To take reasonable care to provide that information. Now, of course, for example, if the customer was given a sheet of paper which summarised the information, and the customer was given a chance to read it but chose not to take it, then that would not be a breach. Reasonable care would have been taken So that's why I say reasonable care to provide rather than necessarily requiring the provision. As to how those duties, as to how those standards, let's say, were breached on the ground, can I show you please in the judgment at page 146. Paragraph 184 contains the judge's summary of her findings as to actual selling practices on a balance of probabilities. And I wonder whether the court could just skim the lettered subparagraphs of 184, which I'm afraid go over the page, but which give a flavour of the types of mis-selling that we're concerned with.
Yes.
Very grateful. You will have seen in the course of that paragraph reference to a compliance workout. And two of the least promising words in the English language. In combination, they referred to a review exercise that was conducted by GECB in November 1997. And just for your note, that's at paragraph 148 of the judgment. And then the summary of the summary, the real punchline, is in paragraph 185, where in the subparagraph the judge finds systemic breaches of the code in at least the following respects. A routine failure in opt-out sales to make the customer aware that they were purchasing PPI at all and that there was an option to decline cover. Number two, a routine failure to provide even an outline explanation of the policy. Unsurprising given the 20 to 30 seconds allocated for a typical sale. Failure in the fourth line of two to explain that the store was acting as an agent, so no mention of the different parties involved. And Roman numeral 3, a routine failure to draw attention to the summary. That's the summary of cover, setting out exclusions and so on, before concluding the sale. And that is why the judge found that if there had been a private law duty of care owed by GECB to customers, then, quotes, it is very likely that GECB was in breach on many occasions, close quotes. For your note, that's judgment, paragraph 350. But of course, the judge found that there was no duty of care. Can I then turn to why I say on the facts of this case there was? The first consideration in our submission is this. As we have seen, the sale of PPI, the third of the three contracts that I described yesterday, was predicated on the prior establishment of a direct contractual relationship by way of the contract of credit, the store card, between GECB in its own right and the customer. It was only on the formation of that contract that PPI could possibly be sold by GECB as Fickle Fackle's agent, as an attachment or add-on to the store card. And we say that immediately takes us far distant from the facts of, for example, the Williams and Natural Life Health Foods case, on which Santander places such reliance. Because in the briefest of summary, in that case, Williams, there had been an offer taken up by the claimants to enter into a franchising agreement as franchisees and set up a health food store, which was a conspicuous failure. And upon that failure, they sued the company for having breached a duty to supply them with adequate or accurate information as to forecasts and projections of profitability. The company that they sued having gone bust, they then sought to bring in the director of that company and say that he was personally liable, having assumed a duty of care. On the facts of that case, they were entirely unsurprisingly unsuccessful in that, not least because they had never met or spoken to or corresponded with the director. So that's a distinction between the facts of that case and, for example, the facts of the BP and Aon case that we saw referred to yesterday, where there had been substantial contact between the sub-broker and the claimant. But it's all a factual question. And we say the facts in this case are that GECB was absolutely central to the relationship with the customer in the context in which information was then provided, or more often not provided, as to whether the customer should enter into a subsidiary or ancillary contract of PPI. And indeed, in the starkest of contrast to Williams, where the director had had no contact with the claimant, in this case, Fickle Fackle as principals under their relationship with GECB were deliberately excluded from any contact at all with the customers at any stage of the selling process. And indeed, they were not even given the names of customers after the contract had been concluded. For your note, that's judgment paragraph 49. Because GECB was jealous of its relationship with both the customers, who were primarily its customers under the store card, and also its relationship with the retailers, who were their agents when selling the store card and their sub-agents when selling the PPI. And so we say this was not a case where GECB was merely interacting with customers in its capacity as Fickle Fackle's agent. In fact, by the time it came to sell Fickle Fackle's product, it was pushing a parasitic product on its own customers. The second factor is that in the process of selling that parasitic product, GECB actively promoted it in circumstances where customers necessarily relied on GECB for information about it. We say that GECB knew that it was marketing a complex product with a variety of eligibility requirements and exclusions and types of cover. It knew that, not least because it had, as Mr. Green showed you yesterday, designed the products, as the judge found at paragraph 58. And it knew that customers were in no realistic position to form an informed view and take an informed choice on whether to buy the ancillary product unless they were given information about it, the sort of information that, as we've seen, the judge found the codes required to be given. And in circumstances where GECB was the contracting party at that stage with the customers, qua credit provider, and it controlled the sales process through its relationships with retailers, we say GECB was the party that had control over whether that information was given. Now, I showed you yesterday in the Customs and Excise Commissioner's case, Lord Hoffman deprecating mere resort to headline terms like assumption of responsibility or proximity, and preferring what he called lower order principles. And can I show you a later distillation, a very short one, of some of those lower order principles? Can we go please to the Authorities Bundle, Volume 2, tab 24, page 646. And you'll see this is a case JP SPC4 and Royal Bank of Scotland. It's in the Privy Council. The reason it's in the Privy Council is because in this case, some claimant investment funds sued an Isle of Man bank for allowing their funds, which they beneficially owned, to be paid out of the bank's customer's account by a fraudulent customer. And the Privy Council upheld the summary disposal of that claim against the bank because it found the bank owed no duty of care. It considered in particular that liability should properly be formulated under the tort of dishonest assistance if it was to be formulated at all, and that would be undercut because the bank was negligent but innocent. But I looked at the summary of the case law by Lords Hamblin and Burrows at the bottom of this page, page 646. And you see there they say an examination of the case law indicates that the factors which have been of particular relevance in determining whether there is an assumption of responsibility in relation to a task or service undertaken include: 1, the purpose of the task or service and whether it's for the benefit of the claimant; 2, the defendant's knowledge and whether it is or ought to be known the claimant will be relying on the defendant's performance of the task or service with reasonable care; and 3, the reasonableness of the claimant's reliance on the performance of the task or service by the defendant with reasonable care. As to factor 1, we say that the task of marketing or providing information about PPI was undertaken purportedly for the customer's benefit, because the customer, having entered into a relationship of credit with GECB, was then told by GECB, or on GECB's instructions by the retailer as their sub-agent, that the PPI was for their protection. It's payment protection insurance, that the credit on the card could be protected or secured by taking out the policy. So they were exposed under the credit agreement and then offered a way to mitigate that exposure. And we say that is consistent with a duty to give at least proper information as to the basic terms of that proposed and purported protection. As to Roman numeral 2, the defendant's knowledge, well, I've touched on that already. GECB knew the nature of the product and also knew that the customer couldn't possibly be expected to form any sort of judgment on it, absent that information required by the codes. And as to 3, we say the customer was reasonable in assuming, even if he or she might not have consciously formulated it in this way, in assuming that a reputable store card provider pushing a supposedly protective product on them would take reasonable care to give them the basic information they required to understand whether it could possibly be suitable for their needs. The third factor we rely on is that GECB had actively announced to the world at large that it would personally uphold standards of good PPI selling. And the announcement to the world that I have in mind is the FLA code. You will have seen in the judgment that as well as the BIA and the ABI, which were insurer trade bodies, there was also the FLA, the Finance and Leasing Association. That was a body not for insurers, but for providers of credit. And in 1993, the FLA, of which GECB was a member, published its code. Can I show you that, please, in the authorities bundle? Tab 3, starting at page 24. You see the title page on page 24, Code of Practice. And then if we flick down, please, to page 26, where the key provisions start, you will see on the top left, this code sets out standards of good practice for the finance and leasing industry and is intended to assure all who obtain facilities from full members of the FLA that they are doing business with reputable organisations. And I emphasise the words, is intended to assure all who obtain facilities. This isn't just a code which is subscribed to behind the scenes by industry members because they want to improve their practices. This is a code which is published to the world with the express intention of providing assurance to those with whom they do business, including the customers in this case.
I'm not quite sure where this goes. First of all, this is all about the credit agreement, not the PPI.
Not quite, my lord, no.
No?
If you'll bear with me, I'll show you it touches on PPI specifically.
And are you saying that consumers generally were aware of this?
There's no evidence on how effective the FLA's promulgation of the code was in terms of penetration to the minds of the average shopper, no. But I would emphasise, as we saw yesterday in the case law, the test here is, as well as being one to be measured in all the circumstances, an objective one. So it doesn't matter whether a particular customer regarded GECB as owing a duty of care, or indeed whether GECB regarded itself as owing a duty of care. But in all the circumstances, I invite the court to look at the position in the round. And part of those circumstances, I say, that's relevant, is that GECB had said to the world at large that it, in its own capacity as a seller of credit, would also take care directly in terms of PPI. So can I show you on the next page, page 27, please, some provisions which are of a general nature, but which in my submission are consistent with an undertaking of responsibility. Section 1, members shall conduct their business lawfully, comply with all relevant legislation, judicial decisions, and trade fairly and responsibly, behave at all times with integrity, and endeavour to ensure that credit brokers, suppliers of goods and services financed by the member and other persons with whom the member has commercial relationships do likewise. 1.3, act responsibly and with care in the day-to-day conduct of their business. 1.9 has training requirements to promote that. 2.1 says the association and its members shall publicise the existence of the code of practice and where appropriate provide details of the conciliation and arbitration scheme. And then in terms of my Lord's question about
4.2.
credit, your Lordship is way ahead of me, indeed. Section 4 specifically credit protection insurance, so PPI. And you see 4.2 and 4.3.
Yes.
I don't say that this in itself is either the necessary or sufficient answer to the question the court has to answer. But I say it is part of the overall objective factual matrix within which you will decide whether objectively either GECB can be said to have assumed a responsibility, or to use the broader classic Cockerill test, whether there was necessary proximity and whether it's fair, just and reasonable to find a duty in all the circumstances. Santander, in its skeleton, pours some scorn on this by saying that well, actually I'll show you, it's paragraph 48, please, core bundle, tab 5, page 48. I think that may be the wrong page number. I'll just turn it up. 79, grateful. Page 79, paragraph 48.
Yes.
And in the third line, they say, it is well established that even a mandatory statutory regulatory responsibility, which the FLA code was not, does not give rise to a coextensive common law duty of care. And they cite their CGL group, and in the footnote, case of Green and RBS. Well, I've got no problem with that proposition as it's stated. That is indeed what those cases find. And they find, in particular in those cases, that it would potentially undercut the statutory regime, which, as we know from ground one, is careful to give a private law right of action, but only for certain regulatory provisions, those which are rules. That's the effect of 138D2. To impose a general duty simply because there is any form of responsibility. And it's also said in that case, in CGL in particular, that it may not suffice to say there's been an assumption of responsibility where a duty has been thrust upon a regulated person and they don't have actually any choice about it. But I say that proposition is entirely irrelevant to the argument here, because the point here is, as is emphasised by Santander, the FLA code was not a statutory responsibility that was thrust upon GECB. It was a voluntary declaration of responsibility that GECB chose to make. And it chose to do so expressly, as we saw, in order to assure those who were doing business that they could do business with them. So there's no question of undercutting statutory responsibility. It is a question, if a question at all, of whether GECB in all the circumstances should be held accountable and held to its word in that sense by finding that there was a private law right of action. And the fourth and final set of factors we rely on is to ask the court whether there are any relevant policy considerations going either way on the question of whether GECB objectively owed its own duty to take reasonable care. And we say the policy considerations, such as they are all one way in favour of the duty. Again,
can I just come back to one point?
Of course.
Considering the position of Fackle, who were the principals,
Yes.
would they have owed a duty of care, or does the line of cases in CGL and Green mean that they don't, because they are regulated entities?
I don't believe that line of cases would bear on the point, because that was limited, the principle in those cases, to the narrower proposition of whether you could spell a private law duty merely out of the fact that there was a regulatory duty.
Right, so what's the answer to the question?
The answer to the broader question is, in my submission, it's perfectly possible in all the circumstances for a private law duty and a regulatory duty to coincide. And in CGL, it did touch on that in the sense that it said if there had been an assumption of responsibility by the regulated entity sufficient for private law purposes, then it may well have overlapped with the regulatory responsibility under, in that case, the insurance conduct of business rules. So there's nothing offensive in my submission about having parallel duties, tort and regulatory, just as there's nothing offensive in itself in having parallel contractual and tortious duties. And indeed, as we know from the broader case law, where those exist, that can end up being very helpful to a claimant because it may be, in particular, different limitation rules apply. So unless there's a conflict, we say a specific conflict, there's no general problem.
Are you saying that a duty would exist in this case?
It may well have done, yes, it may well have done, my lady. And very similar arguments would have been raised against the principle. In particular, instead of someone referring to the FLA code, they would refer to the BIA and the ABI code. And it would be said, in terms of the principal's responsibilities, that although in fact GECB controlled the process, it could have been open to the principal to negotiate a different deal. On the judge's findings of facts as to the power dynamic, that may not have been practically possible, but in theory, Fickle could have chosen a different agent or imposed more onerous requirements on the agent. And this was all litigated below in terms of whether Fickle had failed to comply with their own duties of training and so on. And the judge found they materially hadn't, they'd acted reasonably. But in principle, yes. And in principle, I say there's nothing unorthodox because of the cases we looked at yesterday about there being multiple targets. And the reason, in fact, of course, that we're arguing all this under the broad heading of a Contribution Act cross appeal is that where one has multiple targets, where the underlying victim chooses to sue or get regulatory redress from one, it's natural we say that they can then seek contribution from someone else as part of the same relationship. In terms of policy, in cases like Williams, there was an obvious reason not to too readily saddle a director with personal liability, because that smacks of piercing the corporate veil. In the Invulnert case that we saw yesterday, the yacht insurance case, we saw there were references to some cases where there will be a careful delineation of responsibility through, for example, a complex series of building contracts. And so those are all possible cases where there are policy reasons not to find too readily a direct duty. We say this case is the opposite. From a policy perspective, it was GECB that not only controlled the process of sales, but took almost all the benefit from the sales, as I showed you yesterday, and consequently faced a very real and, in the event, irresistible temptation to missell. And without unnecessarily entering into legal philosophy, one could ask, well, what is the purpose of duties of care? One is, of course, that when they are breached, the courts will provide compensation. But another reason that duties of care exist and are promulgated is that if people are aware they're under a duty of care that has consequences if breached, they may take more care and seek to satisfy it. And we say this is a million miles from a classic agent situation where the agent is simply sent out to follow his principal's instructions and to sell his principal's product for his principal's benefit, subject to getting a commission usually. Here, GECB is marketing to its own established credit customers a policy from which it takes almost all the benefit. That is very far from the classic case. And just to show you one paragraph of the judgment, if I may, which puts some figures onto that. Can we turn please to Core Bundle tab 9, page 130. And you see at the bottom of page 130, paragraph 122, you see the judge reciting Mr. Green's invocation of the gross injustice, which would result if Santander were permitted to avoid liability to make any contribution to AXA Genworth's losses. And it's fair to say that the judge had considerable sympathy with that, but then rightly put it out of her mind in general terms as a jury point. But in the course of explaining how the point was made, you see the figures at the top of page 131. Yes. And so when the redress was paid, and this is relevant also to ground floor, which we'll come to very shortly, you see there 25% of the redress related to the return of PPI insurance premium, of which GECB had received most historically. But 30%, so more than the actual refunded premium, related to interest charged by GECB. Now that is interest charged by GECB qua credit provider on the store card. Because what would happen in simple terms is the balance would be supplemented by the PPI premium, and if it wasn't cleared, then it would form part of the balance, which would then attract interest. It was a terrific product for GECB. And so that's 30%, and then 45% is then statutory interest on the previous amounts. And so I don't deploy this as a jury point to say they've got all the money, what rotters, although there's a strong factual basis for that submission. But the point is here, this shows in my submission the intricate interrelationship of the PPI policy with the credit policy and the centrality of the credit policy and GECB's role qua creditor in this product and in the process and consequences of mis-selling. And so for all those reasons, we say GECB objectively owed that limited duty to take reasonable care as the primary contracting party on which customers necessarily relied to honour the public commitment it had given. We're now in the home stretch in terms of ground four, but before I leave ground three, I should just note that I have not addressed you on any argument that you should find a duty of care because there is an incremental extension by analogy of the duties of an insurance broker, because I don't need to. It's a distraction. We did raise that below. It is referred to in our skeleton. I don't pursue it. I say there is an established category in terms of those who owe duties of care, as we've seen, and I don't go further.
Thank you.
In terms then finally of ground four and GECB's liability under the Consumer Credit Act, this is a very much shorter point. Can I show you how it emerged in the judgment? Core bundle, page 180, please. You see the heading halfway down the page at paragraph 355, Consumer Credit Act 1974. Just for information, although it's the 1974 Act, these provisions were introduced much more recently by the Consumer Credit Act 2006 with effect from 2007, and they replaced and were intended to extend the scope of previous provisions in the 1974 Act, which related to what were called extortionate credit bargains. So the move here is away from extortionate credit bargains, which was thought to establish quite a high threshold, to a much broader sense of unfair relationships. And you see there, it's a little bit like the unfair prejudice provisions in the Companies Act. First of all, it sets out what the unfairness is, and then it gives a remedial power. So 140A sets out what the unfair relationship might be. The court may make an order under 140B in connection with a credit agreement if it determines the relationship between creditor and debtor arising out of the agreement, or the agreement taken with any related agreement. And that's important because that's how we get to the relevance of the PPI policy. Is unfair to the debtor because of one or more of the following. You can see A to C. Very broadly defined. And equally broadly, subsection 2. The court shall have regard to all matters it thinks relevant. And then over the page, we have the remedial section 140B. An order under section may do one or more of the following. And A is to require the creditor to repay in whole or in part, any sum paid by the debtor or by assured by virtue of the agreement or any related agreement. So again, you see the reference to related agreement, so that covers PPI. And we flick down, please, to where the judge then set out her assumptions as she expressed them in paragraph 356. She said she was prepared to assume that the store card agreement was a credit agreement and the PPI policy was a related agreement. In my submission, that's obviously correct, and I don't understand it to be in dispute. Letter B, it does not matter that the credit agreement and the related agreement are between different parties. A credit agreement can still be unfair in relation to matters which arise in connection with the related agreement. So the related agreement can taint the relationship under the credit agreement. Again, that's right, I don't believe it's disputed. In paragraph 357, the judge referred to the guidance on assessing unfairness in the Self and Santander case. The court sees what's said there, it's not controversial, it's a broad and holistic assessment. And she applies that to PPI. In paragraph 358, she recites our arguments below about the nature of the unfairness, which I hope is familiar from the sorts of points I've been making to date. In paragraph 359, she agrees with AXA that it does not matter that a remedy under the 1974 Act was purely hypothetical, because the Contribution Act, as we saw yesterday, requires only a liability which has or could be established. Again, not controversial. And then the sting is in paragraph 360. More difficult, however, is the fact that repayment would have been a discretionary remedy. The objective of section 1.6, that's 1.6 of the Contribution Act, is not to create or deem a liability where none can exist, but to recognise it need not be formally established. In this case, there was a whole range of possible remedies under section 140B, some of which did not involve payment at all, for example, altering the terms of the agreement. In those circumstances, repayment might never have been ordered, and it is therefore difficult to see how GECB would be said to be liable to make such repayment. Now, the reason that we say that that was an error of law is because the Contribution Act is concerned with liability for the same damage, as I submitted yesterday, under ground 1. It does not require that the same damages should be the subject of liability on the part of contribution claimant and contribution defendant. And therefore it's perfectly possible under the Contribution Act for compensation to the underlying sufferer of damage to be provided by the contribution claimant and the contribution defendant in different ways. They do not have to both involve, indeed neither of them need involve, monetary payment. And the fact that there's therefore a discretion on the part of the court in the hypothetical claim by sufferer of damage against contribution defendant, and that in the course of that discretion a non-monetary compensatory order might be made, is no barrier. To take again perhaps a glib example, if two people are contracted to dig a swimming pool and they don't bother doing so, and one of them settles with the claimant and pays them a sum of money to enable them to go out into the market and get someone else to do the job, it is no answer on the part of the other contractor for them to say, I'm not liable because if the disappointed swimmer had chosen to sue me, I might not have been ordered to pay them money. I might have been ordered to dig the pool by way of specific performance. One can multiply these examples by way of parlour game. But the point of my submission is simply this, it doesn't matter that there is a possible remedial menu in that hypothetical claim. What matters is that whatever remedy might have been given is capable of valuation in money terms. Because as soon as that is capable of valuation in monetary terms, the court is able to do the exercise under Section 2 of the Contribution Act, which is to apportion between contribution claimant and contribution defendant. Now, can I try and make that good by closer reference to the terms then of the Contribution Act?
Sorry, just, you say the remedy must be measurable in money terms.
Yes.
This is the remedy in the hypothetical claim, is it?
Yes.
So you would have to measure in money terms
Yes.
what the court might have ordered
Yes.
under Section 140A.
Yes.
How would you do that?
Well, if we look at 140B, at only one is quoted in the judgment. But if we can look at the authorities bundle, please, you will see 140B appears behind tab 1. On page 7. A is what the court quoted below. Require the creditor to repay any sum paid by the debtor by virtue of the agreement or any related agreement. Now that is the obvious, in my submission, remedy in this case, because the natural remedy, if it's found that one has been missold PPI and that one wouldn't otherwise have bought it, then the natural remedy is a refund. It's precisely what is done under DISP. But there are, because this covers all sorts of types of unfairness, some of which may be more complex. One sees B, for example, require the creditor to do or not to do anything specified in the order in connection with the agreement or any related agreement. It's hard to see how that would apply in this case. But if, for example, and this is quite an extreme exercise of imagination, if, for example, a court decided that a better way to provide compensation for the mis-selling of PPI was to order the creditor to give some sort of rebate on credit interest levels so as to provide compensation through that route, we say that would be a fairly eccentric exercise of discretion, but if it was made, it could be valued.
I understand that, but given the fact that no claim has ever been made under the Consumer Credit Act, how does the court, considering the claim under the Contribution Act, value potential remedy under the Consumer Credit Act? That's my question.
Yes, well, it does that by looking, my lord, at what the Consumer Credit Act claim would be for and what the remedy would be seeking to do in terms of remediation. And in my submission, what it would be for, the hypothetical claim, would be for compensation as against the losses incurred by the missold PPI product. And that would amount to, the loss would be the premiums plus interest.
Right.
And however the court chose on a hypothetical claim to give effect to it, in my submission, it would obviously be 140B. But the fact that there are other conceivable remedial discretions doesn't change the fact that what would be remediated would in every case be that same damage. And so that's always capable of valuation. Can I just show you one paragraph in judgment which gives an indication of what I've just said in terms of the purpose of remediation? It's in the authorities bundle, volume 2, please. Tab 25.
You say that what would be remediated is the same damage, and you stress the point that damage is not the same damages.
Yes.
So you might say that the question I've asked you is a red herring, because what needs to be assessed in monetary terms is not necessarily the extent of the contribution defendant's liability, primary liability, but the money which the contribution claimant has paid out.
Well, yes, Miller, I would never venture to describe any of your questions as a red herring, but it's right to say that when one looks at what the court, why is all this being asked in the context of a contribution claim? It's so you can get to the end point of being able to apportion the loss. And the starting point is as you say, what the contribution claimant has in real life paid out. Now, it's absolutely clear law that doesn't have to be money. We know that from BDW. Remedial works were done, that's fine, there was no barrier. And my submission is simply, it works the other way as well, if we need to get that far. But just
Right, you
on
wanted
that,
us to look at another authority?
yeah, if you wouldn't mind. Bundle 2 of the authorities, tab 25, page 667. And we're in the Supreme Court in the Smith and RBS case. Lord Legate, we've seen a lot of both RBS and Lord Legate in various decisions in this case. They're both at their apogee in this case. Paragraph 25, he's talking about that broad and holistic assessment under 140B. And he says the legislation gives the court the broadest possible remedial discretion in deciding what order, if any, to make. Gives the court an extensive menu of options from which to select, that says nothing at all about how the selection may or should be made. On the face of it, the court's discretion is entirely unfettered. It is, I think, clear that the court is not in these circumstances required to engage in the kind of strict analysis of causation, loss, and so forth that would be required, for example, in deciding a remedy in contract or tort. Some constraint is, however, imposed by consideration of the general purpose of an order under 140B. In principle, the purpose must be to remove the cause or causes of the unfairness which the court has identified, if they are still continuing, and to reverse any damaging financial consequences to the debtor of that unfairness, so that the relationship as a whole can no longer be regarded as unfair. And that's why I say the natural, inevitable order would be for a repayment of premium and interest, because that is the order that reverses any damaging financial consequences to the debtor of that unfairness. Finishing off then, just to show you Santander's skeleton of this. Core bundle, tab 5, page 80, please. And I'm looking at their paragraph 53. They deal with ground 4 with admirable economy over the course of this page and the first half of the next. In 53, they say sections 140A and B involve a sui generis statutory action against a credit provider alone, which could not be brought against insurers or be a common liability. No such action was ever brought, and none of the complaints at issue involved such a claim under the CCA. Well, you have there, in my submission, two obvious heresies. The first is to say that it's a problem, supposedly, because the action could not be brought against the insurers. Well, of course, that's not right. One knows in the Contribution Act that the liability against contribution claimant could be, for example, in contract, and the liability against contribution defendant in, for example, tort. One party may own only a contractual duty, one only a tortious duty. It doesn't matter that they're different types of action. And the second heresy is in the last sentence, that no such action was brought. Well, no, it's hypothetical. And as the judge rightly found, of course, that's often the nature of contribution claims. Victim chooses to sue one person liable, and because they're made whole, they don't have to sue the other. And finally, paragraph 54, Santander says that they involve the CCA provisions as a discretionary assessment and a discretionary remedy. Well, we've touched on that. And they say unless and until this assessment is made on an application to the relevant court, there is no liability in existence. We say, no, that's not right. When one has a legal claim for a remedy, in my submission, it does not matter that the court may have a remedial menu from which to draw. Again, I've given you the example of the swimming pool contractor. The question is simply, and going back to my submissions on ground one, is there a liability which sounds in law, which is enforceable in courts? In my submission, plainly there is. And we should be allowed on remittal to go through the sample of complaint files and show, to the extent we can, how many of them would have attracted on their particular facts a liability on GCB's part through that hypothetical claim, either under negligence or Consumer Credit Act. And we should then be allowed to extrapolate the results and get contribution accordingly. I'm very grateful.
Thank you very much. Who on the Santander side is going to deal with this bit? You are, Mr. Howard, right?
I'm afraid so. I just have the as you know, by its contribution claim, AXA seeks contribution under the 78 Act in respect of the redress payments and the sums paid to the OR. No other basis for claim. It's very important not to lose sight of this in light of some of the submissions that are made. There's no other basis for the claim, so it wasn't said that they could say they were liable at common law and they were seeking a contribution on that basis. They were simply putting it on until closing, and they tried to extend it, but the judge didn't allow them to, on the basis of their regulatory liability. Now, the judge correctly held that a claim for contribution on that regulatory basis cannot succeed. And in our submission, that conclusion necessarily follows from the terms of the Act and the basis on which you can get a contribution. Pursuant to Section 1, and we'll turn it up in a moment, the entitlement is only granted to someone who is liable in respect of any damage suffered by another person. That means Section 1(6), a liability which has been or could be established in an action brought in England and Wales on behalf of the person who suffered the damage. And the redress payments, quite simply, were not paid pursuant to any such liability, nor were the sums paid under the OR settlement. So if AXA can't bring itself within the statutory scheme, and it can't, there's no claim to contribution. Now, before I consider the statutory language further, in the light of what I would describe as extravagant submissions that have been made, it is necessary to remind you of the background to the Act and how it came to be enacted in the terms that it did. You don't have to take it from me because it's all been explained by none other than Lord Bingham in the Royal Brompton Hospital case. And if you would turn to that in tab 12 of the authorities, and it's worth, just before we look at what Lord Bingham said, to show you also something from Lord Hope and Lord Stane. But what this concerned was a contribution claim in a building contract between an architect and a contractor. And it's just interesting to see that this is one of those cases where in the House of Lords, they said the statute, the wording of the statute is clear. And although economically you could see some justification for people seeking contribution, you couldn't because you're not within the Act. And I'll show you two cases of the Court of Appeal that they held were wrongly decided on this, which is quite important to understand. So if you just look at the holding, because you can pick up sufficient from that, dismissing the appeal, although the purpose of the 78 Act was to enlarge the previously restricted category of causes of action, I stress the word there, causes of action, capable of giving rise to a claim for contribution, the requirement that contributors were subject to a common shared liability remained at the root of the contribution principle. The right to contribution conferred by section 1 and 6 might be claimed from any other person, whatever the legal basis of that person's liability, provided it was in respect of the same damage. And those words bore their natural and ordinary meaning and were to be applied without gloss, either extended or restricted, to the proper evaluation and comparison of claims alleged to qualify for contribution. Since in respect of extension of time and of the instructions for land as camp proof membrane, the claims against the contractor were for delay, against the architect for the impairment of the employer's ability to proceed, against the contractor, the statutory criterion for the two claims for the same damage was not satisfied. Now, just as you can see from the headnote, the law in this area evolved, and the purpose of the 1978 Act was to extend the causes of action in respect of which you could seek contribution. And that's the important thing that you have to bear in mind. Now, if you go to the judgment of Lord Bingham on page 190, at paragraph 2, his lordship explains how the common law had originally stepped in, and by allowing in certain circumstances where there was a common liability between parties that you could get contribution. And then he explains at paragraph 3 how, as he puts it, the advent of the motor car, obviously you've got many more accidents being suffered, and paragraph 3, he explains the background and the law revision committee that led to what was, and he sets it out at 191 letter F, the law, section 61C of the Law Reform Married Women and Tortfeasors Act of 1935. And so, if you see the terms of that, where damage is suffered by any person as a result of a tort, any tortfeasor liable in respect of that damage may recover contribution from any other tortfeasor who is or would have sued have been liable in respect of the same damage, whether as a joint tortfeasor or otherwise. Now, the difficulty that the 1935 Act gave rise to was this limitation on the nature of the cause of action. So it had to be tortfeasors. And what his lordship then explains in paragraph 4, so you see in paragraph 4, 3 lines down, well, you see the beginning, with the Law Revision's third interim report and section 61C of the 35 Act were directed only to the liability of those who committed tortious acts, whether jointly or concurrently. This limited field of application came in time to be recognised as a weakness. The section 61C did not apply to wrongdoers other than tortfeasors, and did not apply to only one tortfeasor. And then he explains the Law Commission 77 report addressed that, and he goes through the bill. And if you go to paragraph 5, he explains that it is plain beyond argument that one important object of the 78 Act was to widen the classes of persons between whom claims for contribution would lie, and to enlarge the hitherto restricted category of causes of action capable of giving rise to such a claim. It is, however, as I understand, a constant theme of the law of contribution from the beginning that these claim to share with others his liability rests upon the fact that they, whether equally, would be or not a subject to a common liability. and there was nothing in the Act which weakened that. So the point was that, as he explains, the 1978 Act was designed to widen causes of action giving rise to a claim for contribution, but it didn't weaken the requirement that firstly there had to be a cause of action against both parties, and secondly that had to be a cause of action in respect of the same damage. Now, whilst we have the case open...
Can I just ask a question?
Yes, ma'am.
This is a very clear exposition of the history of the legislation.
Yeah.
And in 1935, as you've pointed out, that statute applied to tortfeasors, in addition, presumably, to the common law principles summarised by Lord Bingham previously, co-contractors.
Yes, but the common law principles were pretty limited.
I understand that. But when we come to the 1978 Act, that certainly repealed the 1935 Act, correct?
Yes.
And would have replaced what were previously the common law principles. In other words, it legislated for the territory of contribution.
Well, I think that whether
It may not matter.
I don't think it matters. I don't actually think, because you do have, for instance, other principles. Certainly you have other equitable principles that sometimes people might rely on.
But it certainly replaced what was in the 1935.
It absolutely repealed the 1935 Act. That was the whole purpose. Because the 1935 Act, as Lord Bingham explains, motor cars and people driving along, two cars causing accidents. That's what provoked.
Put my question another way: if we're talking about a right of contribution on a statutory basis, the 78 Act is exhaustive on that point.
Yes, absolutely. Yeah. I mean, I'll come to it. I mean, the 78 Act, when it widens the causes of action, so you can get a contribution, as we all know, for instance, if party A is liable for breach of contract, party B is liable in tort, or party A is liable for breach of contract and party B is liable for breach of statutory duty. Providing those causes of action that give rise to our liability in respect of the same damage, that's what the 78 Act was designed to deal with. Now, again, just so one has it in mind, the next point I wanted to show you was some dicta of Lord Coke at page 207, at paragraph 45. And he referred to the Friends Providence case, and I'll show you that that was wrongly decided, which is referring to here Lord Justice Auld in that case, referring to the words any damage suffered by another and whatever the legal basis of his liability, etc. He said it was difficult to imagine a broader formulation to an entitlement, and the 78 Act was intended to be given a wide interpretation. Lord Justice Keane followed those in Hurstwood, another wrongly decided case, as I'll show you, when he said it was necessary not to be over-influenced by the possibility of formulating the damage for which one party is liable in different language from that which is employed to define or describe that for which another party is liable. And then he says it's clear that the purpose of the 78 Act was to extend the law to enable a contribution to be recovered in situations where it was not previously available. So just stopping there for a moment, the purpose of the 78 Act was to allow you to rely on different causes of action which you couldn't do previously. In that respect, the wording in section 6.1 is undoubtedly very wide. But the next sentence is very important in relation to submissions you've heard. I think it is a misconception to regard the Act as a whole as being open to the widest possible interpretation. And it is useful then to go back, if you would, to page 203, where Lord Steyne deals with the two cases in the Court of Appeal, which I told you were wrongly decided, because it's instructive and to understand that. And the reason it's instructive is that in contribution, it's not about arm waving and airily-fairily saying, oh, well, you know, it's all very similar and it would be unjust if I can't claim contribution. And that's what actually happened in the Court of Appeal cases that were wrong. So, yeah. Just if I interrupt myself to answer my Lord's question, Section 7.3 apparently of the 78 Act supersedes any other right to contribution in corresponding circumstances, so except for contractual claims. But picking up paragraph 33, His Lordship says he's going to refer to 4 cases. The first is Friends Provident, which we've already seen referred to, and he quotes, and it's interesting to see what was being discussed there. He's quoting from Lord Justice Old. In my judgment, despite the distinction between a claim for restitution and one for damages, so each may be a claim for compensation for damage under what Section 1 and 6 of the 78 Act. The difference between asking for a particular sum of money back or an equivalent sum of money for the damage suffered because of the withholding is immaterial in this statutory context, which is concerned with compensation for damage. Now, the authors of Goff and Jones criticised that, and they said to conclude that a restitutionary claim is one for damage suffered cannot be justified in principle, nor is it, in our view, consistent with the natural meaning of the statutory language. A claim for restitution cannot be said to be a claim to recover compensation within the meaning of Section 1. And he says he agrees with the criticism of Friends Provident. To this extent, it cannot be accepted as a correct statement of the law. And then he says it's necessary to refer to the Hurstwood case. Relying on the observations in Friends Provident, the Court of Appeal held that the claim by an employer against a contractor for negligent site investigation services and the claim by the employer against insurance brokers for failure to insure against the contingency claims are claims for the same damage, entitling the brokers to claim a contribution against the contractor. The fact is, however, the insurance brokers had no responsibility for the remedial work. In my view, the extensive interpretation of Section 1 adopted by the Court of Appeal led to the conclusion not warranted by the language of the statute, and so it was wrong. Now, you will recall, I'm sure, that AXA sought to denigrate or dismiss Santander's argument and the judge's conclusion as what they describe as taking, quotes, technical, quotes, points. Now, one might legitimately ask whether it was technical of the House of Lords to decide that firstly Friends Provident and secondly Hurstwood were wrongly decided in the Court of Appeal. Was it technical of the House of Lords to decide that the architect in Royal Brompton could not obtain a contribution? Well, I suppose if by technical you mean applying a statute in accordance with its terms, the answer would be yes. But one might think that there is nothing wrong with that. In short, AXA's characterisation of the arguments as technical is simply an attempt to avoid the consequences of the statutory scheme. And their cross-appeal involves and requires a novel and expansive interpretation of the 78 Act, which has no foundation in the statutory language. Now, the law of contribution has always required a common liability for damage that is actionable. As you've seen, the purpose of the Act, 78 Act, was to widen the causes of action, the cases in which contribution could be sought. But it was no part of the purpose of the Act to dispense with the requirement that the liability should be actionable at the suit of the person who suffered the relevant damage. So if we turn to the Act, and I would suggest one has to at all times keep this in mind. It's at page tab 2, page 13. We go to section 1(1), subject to the following provisions of this section, any person liable in respect of any damage suffered by another person may recover contribution from any other person liable in respect of the same damage. So, as you've seen in 35, you had to be tort pieces. Here, liable has been extended to any basis of liability, but when one goes to section 1(6 over the page, it explains if, stopping for a moment, the word liable would actually tell you that you've got to have a cause of action, but the draftsman made that clear in 1(6. References in this section to a person's liability in respect of any damage are references to any such liability which has been or could be established in an action brought against him in England and Wales by or on behalf of the person who suffered the damage. And that this whole concept, you'll remember, if you just flick up page 191, where we have the 35 Act, the concept of being liable in respect to the damage was what started in 35, just 35 limited it to tort pieces, and that was the big change, that you could sue. It didn't matter if your cause of action was something else. Now, so the requirement for a liability that can be established by action is clear from section 1(1) and section 1(6). Now, so if we turn to the redress payments in this case and the sums paid to the official receiver under the settlement, none of the payments made was made when it was made, and that's a very important point to keep in mind. None was made pursuant to a liability that was or could be established by a consumer in an action against AXA. The actual or apprehended complaints were not the subject of any such action, and they couldn't have been. They were not made as legal complaints, nor were they based on legal liability. They were purely regulatory matters. And AXA paid, and it paid rightly, because it considered itself under a regulatory responsibility to pay, and it was under a regulatory responsibility to pay. And a regulatory responsibility is entirely different to a liability in the terms of the statute which has been or could be established in an action. So the regulatory responsibility that they had was referable solely to their status, or fickle facile status, as regulated entities. It was for those entities themselves, and if they didn't do it, for the ombudsman to determine what redress was required. The court could have had no role in it whatsoever. You couldn't come to court and say, we want redress. In other words, the statute, as your lordships know, doesn't, and they should know, doesn't create a situation where a consumer can come and say, order them to provide me with redress. And fickle facile were required to offer redress where, having considered a complaint, they determined redress was appropriate, or where the ombudsman had said it was appropriate. And you've seen that in the DISP. Yeah. I don't think we need to turn it up again. You've seen that. Now, we've referenced, but I think it is worth just showing it to you, what AXA itself said in the authorities bundle at page 535, is it accurately summarised the position in proceedings between AXA and General.
This is Mr. Justice Bryan's case, is
Mr.
it?
Justice Bryan.
Yeah.
It's at tab 22, and it actually, we picked out a bit later, but the passage actually starts at page 535. None of this is controversial, but it's important to just have the right context. So paragraph 10, he explains the regulatory regimes. I don't need to read that out. And paragraph 11, he explains, importantly, the upshot of all of this is that Fickle Fackle were at all relevant times subject to regulations which required them to have in place the systems for complaints and where appropriate claim redress, and explains the FOS jurisdiction. By contrast, at 12, it was explaining that Santander were not at any times subject to this. And then at 13, AXA emphasises the regulatory context discourages regulated entities such as Fickle Fackle from adopting an adversarial approach to complaints made against them by customers. The key submission was that the consumer redress regime was not about legal liability and differed markedly from what is expected of parties to ordinary civil litigation. Now, the point about that, and they're right about that, is that it's in partly this captures it. Of course, you're not supposed to be adopting the adversarial approach that we're all used to in litigation. You're required to deal with it in accordance with rules. But the point is, it's not about legal liability.
I know we've got extracts from the DISP regime,
Yeah.
but in this ombudsman scheme, and indeed other statutory ombudsman schemes, often you find that the key principles in, for example, DISP, are actually laid down in the statute.
Yes.
I wonder whether we've got enough of the relevant statutory extracts on the question, for example, of no need to show legal liability. You find that in the legal ombudsman scheme.
Yes, but
which is being modelled on this particular scheme.
Yes, but I mean, I think though, Lord, the critical point for the purposes, for present purposes, we can provide obviously with more of FISMA and so on, if that would be helpful.
But it's part of the underpinning. It's the primary legislation.
Yeah, I understand that, but the point I'm making, the question that we're concerned with here is whether what you're doing under FISMA can give rise to a contribution claim.
I understand that.
Yeah, and I'm saying so. And I don't think it's in dispute that there is no. The regime doesn't give rise, in fact, not in dispute, to a cause of action in the hands of the consumer. That's the critical point. Now,
I'm sorry, that very much is in dispute, that the regime gives rise to a cause of action. That's the whole argument.
It seems to me that the real point of difference between you is this. On the facts as they were, AXA paid out redress.
yes,
And it did so by reason of regulatory requirements.
exactly.
And at the moment that it paid out redress, the consumer at that point had no cause of action.
That's right.
But we are required by section 1, subsection 6, to consider not only whether liability has been established in an action, but whether it could be established in an action. So the question then seems to me to be, to what extent do you depart from the facts as they were in order to give effect to the statutory hypothesis?
Yes, I'm not sure that is actually, if I can just explain why I don't think that necessarily quite, one needs to see what section 1(6), what the purpose of it was.
Yeah.
So what, if we could go back to page 14 in the authorities fund. So the scheme of the Act, section 1 you've seen is you've got to be liable in respect of the same damage. Then section 1(2), you can get contribution notwithstanding you cease to be liable, providing you were so liable immediately before you made or were ordered or agreed to make the payment. So it covers a situation, it doesn't matter that you've ceased to be liable at the time when you're seeking contribution, you've got to be liable before you made or agreed to make the payment. Now, what section 1(6) is doing is saying, well, if you have been found liable, then you are liable. Could be is looking at not hypothetical situations in the sense of something else has got to happen, but it's if the person had sued you at the stage at which you entered into the payment or settlement, if the matter had come before the court, did you, was there a cause of action for which you were liable?
Well, I think that is exactly what divides you, because Mr. Campbell has said, well, if you hypothesize an agreed amount for redress or a FOSS award and AXA didn't pay, then there would be a breach of DISP rules, which would give the consumer a cause of action. So
something
he introduces a hypothetical fact which didn't in fact exist in order to complete the consumer's cause of action. And you, as I understand it, say, no, you look at the facts as they are at the time when the payment was made.
I say two things. I say, when I say you look at the facts, it's not that that somebody has necessarily brought a claim against you. They have to. I mean, there has to be the House of Law, Supreme Court considered the BDS case. All of that means, but you're looking at the facts as they exist to test the liability. Are you in fact before you made the payment liable?
Yes.
No.
I understand. That's your argument.
Yes, but the second point that Mr. Campbell makes, we say that is a complete answer. You look at it at that stage. Then the hypothetical situation that we're then considering, where he says, well, you should consider what would have happened if we hadn't paid, if AXA hadn't paid. Then the consumer could have sued. But the question then is, what is the consumer suing for? What is the liability that AXA then has? Now that is a liability for different damage, because the damage at that stage is not the redress payment. The liability is for breach of the statutory duty in failing to follow the rules. Now, in economic terms, on our particular case, it could amount to the same thing. But in legal terms, the damage for which AXA is liable if it failed to pay is the damage caused by breach of the rules. That is not the same damage as caused by AXA's and GECB's mis-selling. And that's one of the points I would suggest, which is it's clear both on the terms of the statute, but it's also clear what the statute is seeking to achieve, and it's also clear from the decisions in the Royal Brompton case. saying that the Friends Provident case
Mm.
was wrong. The claim in restitution and the claim for damages may ultimately, in economic terms, have been the same, but they weren't in respect of the same damage. And that's why we say this is fundamentally misconceived. Or even if we say it's not appropriate actually to see, well, in what other circumstances could the consumer have sued for breach of a different duty, which couldn't arise on the facts. But even if it was, that would not be a cause of action in respect of the damage that we're concerned with, which is the mis-selling damage.
Yeah. And I think in BDW, Lord Legate says you test it on the facts as they exist.
Yeah, exactly, you do. And so that's, in a way, your Lordship has, those are our submissions, and we say that is what clearly comes out of the statute, and why the judge was right that a claim for contribution in respect of a regulatory liability is misconceived.
Yeah.
And you will note, not only is there no authority which supports this, and I would suggest when one reads Royal Brompton, is all inconsistent with it. What you're concerned with is a cause of action in respect of the same damage. But you will note, my learned friend, I mean, this is a novel argument, inconsistent with the wording of the statute, but not supported by anything. There's no Law Commission reports, there's no academic commentary saying there's a problem that needs to be filled. It's just an invention for the purposes of this case. So, now, if I can just perhaps, so I don't go over it too quickly. I mean, your Lordships have seen FSMA and 138D2, and I think you have my point that any action there is an action for contravention of DIS, and it would not be the customer's complaint for which AXA would be liable if the customer had sued. The complaint would not be asserting liability in respect of any damage. It would be asserting breach of the rules and the damage to which that gave rise. So, in simple terms, the damage the subject of the action would be the loss from breach of the rule, and that's not the same as mis-selling. And just saying, well, on our facts, the economic consequences might be the same is nothing to the point. And a refusal to pay, if it had ever occurred, and it didn't occur, would at most have created a new derivative liability arising from non-compliance with the rules. And you can't magically convert a regulatory redress liability or a failure to comply with your regulatory redress liabilities into a qualifying liability. So the question is not, could the customer have sued AXA if AXA had refused to pay? And of course that never arose. The question is, could the customer have brought an action establishing the liability in respect of the PPI damage for which AXA now seeks contribution? And the answer is not. I mean, it might have had a common law action, but that's not what this is about. It couldn't do it by reference to the regulatory rules. And so the fact that the Act encompasses statutory liability as it does doesn't tell you anything, because the statutory liability has got to be for the same damage. Just it's page 16, section 6. A person is liable if the person who suffered it is entitled to recover whatever the legal basis of his liability. And it is I would respect useful to test this by having opened the Civil Liability Contribution Act and at the same time referring to the Respondents' notice at page 34 of the core bundle. And paragraph 1 they say the second set where they say the judge erred in finding the claimants were not liable for damage suffered by the PPI from claimants on the basis that the claimants' compliance with their regulatory obligations had forestalled any claim that would otherwise be made in the civil courts by complainants for redress sums. Now that's not quite an accurate summary, but the correct position, they say, is that liability for the purposes of the Act encompasses the payment of a sum which would have been enforceable by civil action had it not been paid in compliance with regulatory duty. Now, you have to take that and then take section 1 of the Contribution Act, section 1(6) and section 6. And it's really a test. How do you fit that into the Act? I say you can't. This is really as simple as that. So, now, I don't think I need to spend any time on it. My learned friend sought, I think, in writing he sought to do it orally, he did it very faintly, which is to try to refer to extra statutory material. All I will say about it is there is no ambiguity in the language, and so, as the House of Lords said in Royal Compton, you need to apply the Act in accordance with its terms. There's no basis for referring to, I mean, you're very familiar with Pepper and Hart. There's no basis for referring to what Lord Scarman said, but in any event, if you do, you will see that it doesn't actually provide anything to support this argument. And what the House of Lords has already said in Royal Brompton made it clear. It's all about having a cause of action in respect of the damage. It's got to be one that currently exists. So that's what I say about ground 1. And ground 1, we say this is completely misconceived, and that means that's the end of the cross appeal. So I'll then deal with the remaining points, but you won't be surprised to know that I say they're no more promising. Ground 2, if you remember, this concerns the OR settlement, and obviously can't arise if I'm right on ground 1. Leave that on one side. It's unsustainable in that how can you bring this within the Act? As I think my Lord Justice Lewison said, what is it that you say is being asserted? How do we test this? So this isn't like the BDW case. What happened in BDW is the contractor was my clients with Barrett's. In the wake of Grenfell, builders were required, as I'm sure the court knows, to go back and review their sites. So, and responsible builders like Barrett's went back, saw, for instance, what they actually saw here, nothing to do with cladding. They saw that the foundations were faulty and dangerous, and that the flats were in danger, I think, of collapsing. So obviously the sensible thing to do was to say to customers, residents, we're going to repair this and we're going to put you up in alternative accommodation while we do it. But the argument that the engineers were making there, well, you jumped the gun because you had gone in before there was a claim. But in the circumstances where there was a liability, and that was the critical point, then it didn't matter that they hadn't formally intimated it. But here, you've got thousands of, you've got a bulk claim being made. And what you've got to be able to do is identify the claimants and the nature of their claim. We say that simply you can't do that. So the judge's findings, we respectfully say, are faithful to this. But we've set it out in writing. I don't think there's anything I want to add unless I can assist you any further. Ground 3, I want to say a little bit more about, but I don't think I need to say much more. It's obviously unsustainable again if we're right on ground 1, but it's unsustainable because GECB did not owe a duty of care to the consumers in respect of the sale of PPI insurance. And what again is being argued for sub silentio is something which would require a radical departure from established law. I'm going to come to that decision of Mr. Justice Legate's, as he was, in a moment. That was a case concerned with something different, which is whether a sub-broker owes a duty simply to the broker or also can assume a responsibility to his principal. So he's acting on behalf of the principal, but he's down the contractual chain. And the question is, in what circumstances does the sub-broker assume a duty of care to his principal? And the answer, the authorities show, was sometimes he can. We're concerned with a different situation, which is the situation of where party, the agent, is the agent of here the insurer and known to be, and is selling the insurance to the customer. With that, we had all sorts of extravagant submissions about this, saying, I think this is 1,000,000 miles, I think I heard it was the closing cri de coeur. This is 1,000,000 miles from the classic agency case. This is standard agency. Just think about it. If you go and buy, probably none of your lordships and ladyship do this, but if you go and buy a package holiday from Thompson's or somebody, or I think they're now called TUI, they will sell you your 2 weeks in Spain or wherever it is, the holiday and the flight. There'll also be a box, do you want travel insurance, which I think they're required to say you should take it, you actually have to say. And they will sell you travel insurance on behalf of AXA or some other insurer or Lloyd's syndicate or whatever. When doing that, they wear the hat, and this is absolutely standard, of representing the insurer. When you buy a car, very often you go to a car sales showroom, you buy the car, and they offer you car insurance. There are 2 different transactions that happen. Now, so this is the fact that there is an agreement. So in the travel agency situation where TUI have an important transaction with you whereby they sell you the package, I shouldn't perhaps use TUI because it goes on the transcript, a travel company sells you that. They then enter into a separate transaction with you. And in relation to PPI, my learned friend is entirely right. You have the sale of the product. I think he used a pair of trousers. I'm not sure whether that's a particularly good example. But then you have the sale of credit, and then you have the sale of insurance. And the question is, when you sell the insurance, you're actually required to make it clear that you are acting as agent for the insurer at that point. My learned friend actually showed you the rules that say that. So the transaction is one where it is declared that the agent is the agent of the insurer for whom he is acting. So if one asks, well, what is English law about this? If we go to Bousted, which we've got in the bundle, at page 824, summarises the position pretty clearly. It's tab 31. So it's Article 113. If you look at paragraph 9-115, where loss, damage or injury is caused to any third party by any act or omission of an agent, that constitutes a civil wrong while the agent's acting on behalf of the principal. The agent is in general personally liable, whether or not acting with the authority of the principal, to the same extent as if he was acting personally, unless the authority of the principal justifies the wrong. The position is in general different if tortious liability rests on an assumption of responsibility. There, if there is an assumption of liability at all, it may be that only the principal is assuming the liability. And at the foot of the page, at 9-117, the first sentence is dealing with deceit. And then if we go to the top of the next page, it's now also clear that an action in negligence can be brought within a pre-contractual and also a contractual situation against a contractual party personally. By the same token, the existence of a contractual situation does not by itself bar an action against the agent of one of the contractual parties. So the mere fact the agent acts for one party does not always prevent the agent's owing, in appropriate cases, a duty of care to the other. For a period, an expansive approach to the liability of agents under Hedley-Byrne was taken. Thus, in Commonwealth cases, estate agents have been held liable for negligent misrepresentation not made within the scope of their authority on behalf of the vendor to prospective purchasers of land. Beyond this specialised context, other decisions also found agents liable to third parties for misstatements. However, except to the extent that these authorities rest on a finding that the agent assumed responsibility for a statement's accuracy, they would need in the UK to be reviewed in the light of Williams and natural life. Here, the principal director of a small company is held not liable for negligent projections in an advisory memo to a third party, on the basis the director himself had assumed no responsibility to the claimant. The basis of the case was the orthodox one, stress that word, that no tort is committed by the agent, because, as in the case of the solicitor answering inquiries, there is in the particular case no personal assumption of responsibility for the purposes of a duty of care in respect of pure economic loss. The principal might be liable in such circumstances. And then, in the absence of an assumption of responsibility by either principal or agent, liability and negligent misstatement would not arise. Mere knowledge the third party is likely to rely on the statement will not establish an assumption of responsibility. Now, if we could just turn back to Williams, which is in the bundle at tab 11. The House of Lords, Lord Steyn gave the speech with him, everybody else agreed. The important part I would pick out is at page 184, and at section at letter F and below, Lord Steyn was referring to some dicta of Mr. Justice LaForest in the Canadian Supreme Court, and he sets those out at the bottom of the page, and you can see he says there the situation of the individual engineers is quite different. While they may in one sense have expected that persons in the position of the appellant would rely on their work, they would expect that the appellant would place reliance on their firm's pocketbook and not theirs for indemnification. Looked at the other way, the appellant could not reasonably rely for indemnification on the individual engineers. It would have to show that it was relying on the particular expertise of an individual engineer without regard to the corporate character of the engineering firm. It seemed quite unrealistic to hold that the mere presence of an individual engineer's seal was sufficient indication of personal reliance, or for that matter, voluntary assumption of risk. The reasoning is instructive. The test is not simply reliance in fact. The test is whether the plaintiff could reasonably rely on an assumption of personal responsibility by the individual who performed the services on behalf of the company. And that's what the Williams point is about. And in a situation where you have party A is acting and known to be acting as agent for party B and providing information about the contract that C is going to enter into with B, he is unlikely, by reason of those facts, to be assuming responsibility, or for the other party to be reasonably relying on him, as opposed to the principal with whom they're dealing. So the fact that no duty of care is owed by GECB doesn't mean that Fickle Fackle didn't owe a duty of care, which might be breached by what GECB do or don't do. And indeed, that is the perfectly standard position. And if we go,
if I buy the travel insurance from the travel agent, and the travel agent doesn't give me the right information about the insurance, it says doesn't exclude winter sports or whatever it is, my cause of action is not against the travel agent but the insurer. Is that
because he is
the position?
acting? Yes, exactly. That's the Williams principle. The director who gave information, or any contracting situation where you have there a director or an employee of a company who's acting on behalf of the company and providing information in relation to the contract, is just by reason of those facts is not treated as assuming responsibility, or the other side relying on him personally, as opposed to relying on his principal for whom he's performing the service. And if we go to tab 13, which we've looked at, but I can just take you back there, in the Customs and Excise case, at paragraph 36 on page 227 to 228. At the top of the page, Lord Hoffman says, 3 lines down, likewise in a case in which A provides information on behalf of B to C for the purpose of being relied upon by C, it's useful to ask whether A assumed responsibility to C for the information or was only discharging his duty to B. And he then refers to Cockerill. In these cases in which the loss has been caused by the claimant's reliance on information provided by the defendant, it's critical to decide whether the defendant, rather than someone else, assumed responsibility for the accuracy of the information to the claimant, rather than to someone else, or for its use by the claimant for one person rather than another. And it doesn't depend upon what the defendant intended, but, as in the case of contractual liability, upon what would reasonably be inferred from his conduct against the background of all the circumstances of the case. And then the purpose of the inquiry is to establish, in relation to the loss, the necessary relationship or proximity. Now, whilst we've got the authorities open, perhaps I could just ask you to go to tab 18, which was the Invulner case. And this was cited to you as with a flurry as if to say, oh, well, you've got Williams on the one side, and this is the case which shows that you can get to a different conclusion in certain cases. Now, this case is nothing to do with Williams, you can see at pages 358 to 359, where you'll see Williams is not one of the cases referred to. And that's because this case is about something different. It is not about the situation that Williams is concerned with. This is about a sub-broker. So if you go to page 424, paragraph 278, Mr. Justice Leggett correctly points out that a broker who supplies services to a client impliedly undertakes to carry out the services with reasonable care on settled principles, the same communications as establish the contract. In other words, a broken contract, it give rise to the duty of care in tort. Then what he's considering at pages 425 and following is whether the sub-broker owed a duty. So at 284, he explains the question of when a sub-agent owes a duty of care in tort to avoid economic loss to the agent's principal can give rise to considerable difficulty. And that's, as I've said, that's a different question. And you can see, and that's what the authorities show, that in circumstances, sub-agents can, because of their dealings with the principal, assume a direct duty of care. That's not what this is about. And I note my learned friend said today, although below and in his skeleton argument, he had been arguing that the position of an insurance agent was analogous with that of a broker, he now says, I'm no longer relying on that. But he cites this case, which is actually a case about the position of an insurance broker or sub-broker. There it is. So now my learned friend showed you the rules which required, I think we need to turn it up, but when selling the insurance, the GCB was required to say that it was acting on behalf of the insurer and as their agent. Now, the judge in our submission was entirely right and entitled to come to the conclusion that there's nothing about how PPI was sold in practice that takes it out of the norm. So what were you actually left with? You're left with, well, GECB sold a credit contract. That's in, I can't say that's always what's happening in an insurance agency, but in a very large number of insurance agencies, the insurance agent has some sort of transaction that it enters into first, whether it's selling some goods, selling a car, selling a holiday, or selling financial services. All of these things are perfectly normal, and that doesn't take you out of the norm. And the fact that the PPI here, or the insurance is being sold after you've sold the principal product, again, is nothing to the point. The argument that GECB had control over the relationship with the customer, well, that will invariably be the case with insurance agents. The insurance company, that's the point of the agency, but that doesn't tell you anything about assumption of responsibility in this context. And you were also taken to the RBS case today at tab 24, page 646. And again, properly understood, that is not saying anything inconsistent with what.
Which page was it, Mr. Hyde?
Page 646. It's properly.
Yes.
Now, their lordships, Lords Hamblin and Burrows, are simply summarising. At 63, they're setting out Williams, and at 64, factors which are relevant in relation to an assumption of responsibility. And the critical point in Williams, in the situation where you have a tripartite situation and a contractual one, is the third point, the reasonableness of the reliance on the performance of the task by the defendant. And the point about Williams is, and that passage I showed you from Mr. Justice LaForest's judgment, is that where, for instance, there you knew that the engineer was acting on behalf of the company, you're not looking to him personally, you're looking to his principal. And in Williams, you're not looking to the director personally to exercise skill and care, you're looking to his company. Equally here, in relation to things to do with the insurance, you're looking to the insurance company, AXA or FACA as they then were, not to the agent. And there's, as I said, nothing special about this situation. And fickle fatal, as I've said, may well and would have owed the duty of care, but that doesn't mean GECB did any more than that the company in Williams owed a duty of care. Didn't mean that the director did. So we submit that there's no basis for a duty of care here. My only friend relies on the fact that GCB joined the FLA and agreed to abide by its code. That, again, is simply GUCB entering into a relationship with the FLA. It didn't thereby enter into a relationship or assume any duties to consumers. And indeed, going back to insurance agents, they will invariably be the member of a similar trade body, which that doesn't tell you that because they're selling insurance and they have to, as a matter of their regulatory regime, comply with certain standards, that they are undertaking duties directly to a consumer. And of course, we're not saying that GCB didn't owe any duties. They would owe duties to their principal. It's their principal, fickle fackle, that then owe duties to the customer. So, my lords and my lady, that's ground 3, unless there's anything else I can assist you on. Ground 4 is, again, a point I can deal with quite shortly. Now, the point that we were making in writing, which my learned friend says was heretical, I'm not quite sure why he says it was heretical. What we were saying was, and are saying, is we were setting the background for what the claim is. So the background is that this is a claim, or a hypothetical claim under section 140A and B of the Consumer Credit Act, and secondly, no actions actually were brought. Those are just true as a matter of fact. So you're then having to ask, well, could the fact that there is a hypothetical claim, is that hypothetical claim one that can be put forward as a basis for contribution? Now, your lordship said to me, well, we're concerned we could. So I accept that you have to look at what cause of action is available against the party against whom you're seeking contribution. So the question is, does a claim that could hypothetically have been brought under sections 140A or B, is that one which falls within the Contribution Act? And the simple answer to that is it doesn't, because there isn't a cause of action available under the Consumer Credit Act for the damage which has been suffered. There is no, you have to ask yourself, before they paid, or at the time when they paid, was GCB under a liability for the same damage? Well, at that point, they weren't, because whether any court ultimately would award anything against them was a matter of the court's discretion, depending on a whole lot of circumstances, with a range of remedies. And what you couldn't say is, at the date when AXA made any payment, that GCB at that stage was under an existing liability. And we say, again, you've got to look at the words of the statute. You go back to the words of the statute and try and bring in what is being said here. You have to ask yourself, was GCB liable for the damage? And the answer to that, we would suggest, is no. And that's why it doesn't get off the ground. And again, one needs to be quite careful about some of the submissions that were made. So you'll remember my learned friend said, well, amongst the remedies, for instance, there could be something like a rebate on credit. Now, just go back to Friends Provident. So if you're the liability it said you're under is effectively to make restitution, well, the House of Lords have said that isn't a liability for the, in that case, particular type of damage. Here, for the damage caused by mis-selling. In economic terms, it might all come to the same thing, but it's not a liability for the damage. Now, where you've got a discretion and a whole range of things, we would suggest it's just impossible to say there was an existing liability for the damage, or the same damage. So, my lords, we say that again, this is a novel way of putting it, and it doesn't succeed. Yeah. So, I hope I haven't taken things too quickly, but we say this is all misconceived, and when things are misconceived, you can put them rather shortly.
Right. Thank you very much.
I'm grateful. Mr.
Campbell, do you wish to reply?
My lord, I just have a little extravagant arm waving to finish with, if I may. First of all, on ground one and the Royal Brompton case, can I just be clear how vanishingly small any disagreement is between us on Royal Brompton? I entirely accept, as I think I accepted yesterday in response to my Lord Justice Lewison's question, that where there is a different type of damage, then of course the Contribution Act will not avail us. Now, one example put by your lordship to me was the solicitor who allows a claim to become time barred. And I accepted.
An example from Royal Brompton,
yes.
The Canadian case in Royal Brompton. Yeah.
Yes, exactly. Another example would be in Royal Brompton, the case of the architect whose fault it was not that the building was delayed, but who had failed to issue various certificates to the builder along the way, with the effect of impairing the employing entity's ability to recover against the builder. So that's very similar to the idea of the solicitor not causing the damage, but mucking up or interfering with or impairing the ability to seek recovery for that damage. So those are those cases. And I have no quarrel with that. But the simple question in this case is, in your lordship's scenarios 2 or 3 that we considered yesterday, in other words, when there has been a determination on self-assessment or by the financial ombudsman that a crystallised sum of money is due and payable, what is that sum of money? That sum of money is compensation for the damage incurred by customers through having bought a PPI policy that they would not have bought but for mis-selling. That is not some other type of damage. What they would be sued for under section 138D2 is that damage. And that is precisely the same damage that a consumer, if you're with me on grounds 3 or 4, would be seeking to recover in the hypothetical alternative action against GECB. Exactly the same. So unlike, for example, the solicitor, if one sued one solicitor in that situation, you would say, I had a claim, it may or may not have succeeded. It would have depended on all sorts of things, how the witnesses panned out, what side of bed the judge got out of that morning and all the rest of it. You'd claim for loss of a chance. And you say, you've deprived me of that chance of going through the process. That is not this case. The redress is exactly the same sum, and it represents the same damage. That was the first of my 3 propositions under ground 1, and it's not with respect being touched by my learned friend. And the judge, to be clear, regarded that, as I showed you, as satisfied. I don't want to waste time with technical points about whether this argument is open to my learned friend because there's no respondents notice. The fact is, much of his submissions there have been based in various guises on challenging there being the same damage. But actually, the fact of the matter is absolutely clear. What is being sued for, hypothetically, under 138D2 is the same damage as that for which we say GCB is liable. And my learned friend says, well, it may be the same in economic terms, as if that's not enough. Well, in my submission, it is enough. That is the test. If one looks in Royal Brompton itself, can we briefly? Authorities tab 12, page 192. Just the one paragraph from Lord Bingham, bottom of the page.
Give me the reference again.
Yes, my lord. Authorities bundle 1, tab 12, page 192. And at paragraph 6 at the bottom of that page, his lordship said, when any claim for contribution falls to be decided, the following questions, in my opinion, arise. Number 1, what damage has A suffered? A, in this case, is the customer. 2, is B liable to A in respect of that damage? So is Fickle Fackle liable to the customer. 3, is C, GECB, also liable to the customer in respect of that damage or some of it? And then, skipping one sentence about striking out, he says, I do not think it matters greatly whether in phrasing these questions one speaks, as the 1978 Act does, of damage, or of loss, or harm, provided it is borne in mind that damage does not mean damages. And he goes on over the page to say, this seems to me to accord with the underlying equity of the situation. It's obviously fair that C contributes to B a fair share of what both B and C owe in law to A, but obviously unfair that C should contribute to B any share of what B may owe in law to A that C does not. What is that other than an economic test? Damage means loss or harm. The real vice of my learned friend's submission, I say respectfully, is that he conflates the concepts of the liability with the concept of the same damage. Of course, there are different types of liability, and DISP, as he said, is not concerned about legal liability. It doesn't apply legal tests. You don't have a legal adversarial process. But what it produces, as you have seen, is a liability under 138D2. And the real question is that in respect to the same damage? We say plainly it is. As to the other points made on the Contribution Act, my learned friend says that liable means having a completed cause of action. And he showed you in Royal Brompton a couple of references to expanding the 1978 Act, the range of relevant causes of action. I don't run away from that language, but Royal Brompton wasn't about this situation where the question is, do you have to have a completed cause of action? The question there was, do you have to have liability for the same damage, which I've addressed you on. The fact is, as I said yesterday, the Act nowhere refers to causes of action, whether completed or otherwise. And what Royal Brompton says accurately is that the 78 Act expanded the range of types of liability, types of cause of action. So beyond joint tortfeasors, as it was in the 35 Act, to that expansive wording in the parenthesis of section 6.1, breach of contract, tort, etc., or otherwise. The question is this, and this I do say is the real highly technical and unmeritorious point that Santander hangs its hat on. It's to say, if the customer did not have a completed cause of action at the moment of payment, that means, for the purpose of the Contribution Act, Fickle Fackle were not liable to make the payment. And I say that involves reading in to the words in a novel and restrictive way, unduly restrictive way, a requirement beyond the ordinary language of being liable to possessing at the moment of payment a completed cause of action. And I say being liable means having an obligation which, if not fulfilled, can be sued to enforcement. And to test it this way, in every tort or breach of contract, the person who is the breacher always has the option to deprive the sufferer of the damage of a legal claim by prompt payment of full compensation, so as to deprive them of loss. Now that would defeat for a tort the cause of action altogether, because loss is a necessary requirement for most torts, except the strict ones like trespass. And for a contract, it would render the claim liable to be struck out because there was no remedy being sought. The fact is, the person who pays promptly is satisfying a legal liability under DIS, because they know that if they don't pay promptly, the person to whom they have to pay will otherwise have an unanswerable claim in private law. Their liability could be established by that action. And that is a sensible, literal reading of the Act. It is Santander who wish you to technically restrict the concept by reading in words. And if your lordship and your ladyship have any temptation towards that, then I do refer you to the points in our supplemental skeleton about purposive interpretation and purpose. Ground two, I say only this: if you're against me on whether there was adequate particularisation of the official receiver's complaints so as to attract the deeming advantage of section 1.4, I would ask you nevertheless to make clear, as a corollary of ground one, that at least the payment is potentially within the scope of the Act, and then we can have a debate, if necessary, on remittal about how far on the facts, as we might be able to prove them, that there was in fact liability. In other words, how many of the complaints were likely to be good complaints. Ground three, we get into questions of agency law. My learned friend read out a bit of Bousted, which was in its own terms expressly tentative. It said, in many cases, and may be the case. The cases I've shown you including in Vilnert, show that there is no Williams principle which says an agent in a tripartite relationship can never be liable. That's legally nonsense. And to try and explain away Vilnert on the basis that it happened to involve a broker and a sub-broker, in my submission, is equally nonsensical. The principles set out in that case and others that I showed you are about tripartite relationships, where there is a primary contracting party, and that primary contracting party then has some sort of agent or sub-agent or sub-broker. Now, it might be a broker with a sub-broker, it might be, as in Williams, a company with a director, it might be any other business with an employee, or in the case we have here, it could be an agent with a sub-agent. But in any event, the point is one has to look at the specifics. And that's why my learned friend was forced into his little bit of evidence as to how one goes about buying travel insurance. Now, I don't know how my learned friend goes about booking his fortnight package holiday in Magaluf, but when he does, and he clicks on travel insurance, in my submission, it's overwhelmingly likely that there will pop up all sorts of boxes telling him exactly what's happening, including, no doubt, that his package holiday provider of choice is acting as an agent for some other party. And then my learned friend said, well, of course, in this case, this was a transaction where it is declared that GECB was acting as agent for insurer. And he said, well, how can it possibly be then that when GECB is going around declaring that it is merely an agent, that nevertheless it's somehow fixed with personal liability? Well, the problem with that is the judgment. I kind of show you one paragraph of the judgment, which I showed you earlier, but in fairness, I only asked you to skim. Core bundle, tab 9, page 148, please.
Sorry, could you give me the reference again?
Yes, my lord. Core bundle, tab 9, page 148.
Yeah.
And I'm looking at paragraph 185 of the judgment. Now, I showed you this earlier. 185, Roman numeral 2, the judge is here summarising the systemic breaches. You see the word systemic just before the subparagraphs. And she says there was a routine failure to provide even an outline explanation of the policy. I cannot say how reliable the 20 to 30 second time estimate was, but it was GECB's own, and it was stuck with it. Then she says this: the idea that this would have been sufficient for a sales assistant to explain that the store was acting as an agent, to outline the key coverage of the product and the cost, to mention the existence of exclusions and limitations, and to refer to the summary, as well as to secure an express opt-in, is frankly bordering on the delusional. This is not a situation where GECB went about declaring it was an agent. The judge found any such suggestion was systemically a delusional one. And that's no doubt why, for your notice, judgment paragraph 87, the judge noted that until the dispute between the parties kicked off in earnest, complaints about mis-selling tended to be almost universally directed towards GECB by customers, not against Fick and Fackle. So we say there's no answer to our case in assertions about agency law generally or assertions about what was declared and understood in this case. There is no substitute for engaging with the facts as I set them out. And I can't really reply on that because my learned friend declined to engage with them. But we refer you to what we said in our skeleton. I rest entirely on what I said earlier. I do say this is a million miles from a typical agency because you have a position where, as a matter of economic substance, GECB in this position, in this web of relationships, was in substance not really the agent, but the principal.
Can I just refer you to one thing in the light of these submissions? Judge's finding of facts at paragraph 348 page 179, last sentence. Her finding is that vis-a-vis the customer, GCB was still selling as agent for Fickle Flapper.
Sorry, paragraph 348.
Paragraph 348, where she deals with the duty of care. She says, she's made a finding of fact that vis-a-vis the customer, GCB was selling it as agent for Fickle Flapper.
If that is intended as a substitute for an apology for misstating the facts earlier on, it's inadequate in every respect, because that is not a factual finding. It is a recording of the legal position, which is of course true as a matter of law. That's why we're having this debate. Of course they were selling as agent for Fickle Fackle. That's why I've wearied you with so many authorities showing cases where, despite selling on behalf of someone else, or acting as a director or whatever, one can still have a direct duty. So there's nothing in that. As regards ground 4, again, I'm afraid there's nothing to add to what I said earlier. Simply to assert in a conclusory way that because a judge in a hypothetical claim has a discretion, that there is no liability is in my submission, not one you should accept. Liabilities mean the ability to receive a remedy from a court. And the question in this case is, if under either of those grounds 3 or 4, a remedy could have been received for the same damage economically, then the test, we say, is passed. Can I turn my back for one moment?
Yeah.
I'm very grateful.
Well, thank you all for your very interesting arguments. Congratulations on finishing even more quickly than we thought at the end of yesterday. It will not surprise you to learn that we will reserve our judgment, bearing in mind the stage we are in the term. Don't expect it before the end of term. You will get a draft in the usual way. It comes with a fierce embargo, which means what it says, so it can only be shown to those on the distribution list. It will be your opportunity to correct our English and our grammar, but not our reasoning, and not to introduce new points. We would hope that in the light of the draft, you will be able to agree an order disposing of the appeal and the cross appeal. If you can't agree a form of order, please make short written submissions, and we will make the form of order that we consider to be appropriate. The hand down will, when it comes, be done remotely by electronic delivery of the judgment to the parties and released to the National Archives. So there will be no need for any further attendance. Thank you all very much.
Court rise in table.